So we need to talk about a huge ruling which struck down a state's ban on rifles and magazines, which is now up on review but might actually be sent back down because of an error. So let's talk about what is happening. Now, really quick before we jump into this video, I actually wanted to mention that the Gundy's Awards are now open once again. You guys might recall that, over the last couple of years, I have been fortunate enough because of you guys and all of your support and all the love that you've shown me and the channel. I've been able to win the top 2A voices, 2 out of 3 times now. So I've actually won twice, and all of that is because of you guys, because of all of your support. I've actually now moved over to a different category. I'm now an Influencer of the Year, and then also the Liberty Lounge podcast, which I do with myself, my friend Johnny B, and then Jared from Guns and Gadgets. We have a podcast called the Liberty Lounge, which I will link down below if you want to watch it. That's also nominated for Podcast of the Year, so I would love your guys' support. A link will be down below where you can vote. Voting is going to go for about 2 weeks, and you can vote every single day, and every time you vote, you're entered to win the prize for that category. Now, as I mentioned in the intro, in this video, we need to talk about what is now happening in multiple cases challenging the state of Illinois' ban on so-called assault weapons and then also their magazine bans. Recently, we received a huge ruling from the District Court Judge McGlynn, which struck down the Protect Illinois Communities Act, also known as PICA. However, as we all knew, the state was not going to let that stand, so Illinois has now appealed this case up to the 7th Circuit, and they're asking for a stay of this decision. The battle now in the 7th Circuit is about the stay, whether or not that should be granted by the 7th Circuit, whether or not the Judge McGlynn decision should be put on hold. And then also there's a very interesting battle going on right now about some errors that the 7th Circuit maybe believes Judge McGlynn made in his judgment, and maybe sending the case back down for Judge McGlynn to fix his errors. Now, you might remember that originally in multiple cases, a district court issued a preliminary injunction that was intended to halt the enforcement of PICA until the court could reach a final merits on the case. Judge McGlynn outlined how he believed the plaintiffs were likely to succeed on the merits of their claims, essentially that the Illinois rifle magazine ban is a violation of the Second Amendment. However, the state of Illinois appealed those preliminary injunctions to the 7th Circuit, and on review, the liberal and biased 3-judge panel in the 7th Circuit overruled the granting of those preliminary injunctions. In coming to that decision, the 7th Circuit used an analysis that does not align with Heller's common use test or even the recent Bruin decision. Instead, the 7th Circuit concluded that arms protected by the Second Amendment do not include weapons that may be reserved for military use. So they used the military use test, which does not align with the Supreme Court's precedent. And so a bunch of these cases then went to the Supreme Court for emergency intervention. But like I mentioned, the Supreme Court at the end of their last term denied review in all of these Illinois cases. In the denial, Justice Thomas was the only one who made a statement on the denial, and he stated that according to the 7th Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of the arms referred to by the Second Amendment. The 7th Circuit's decision illustrates why this court must provide more guidance on which weapons the Second Amendment covers. He went on to state that if the 7th Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review that decision once the case reaches a final judgment. So although the Supreme Court denied review to those cases, Justice Thomas did make a strong statement saying that they are interested in this type of issue and they will want to review a final merits case. Now, while these preliminary injunction appeals were pending in the Supreme Court, the lower court judge, Judge McGlynn, decided to move all of these cases towards a final merits decision. And recently he held oral arguments in a hearing on all these cases and reached a decision and issued his judgment. Once again, Judge McGlynn found that PICA does in fact violate the Second Amendment and he struck it down. However, in that decision, he stayed the enforcement of his ruling for 30 days so that the state of Illinois could appeal up to the 7th Circuit and seek a more permanent stay if they wanted. Illinois has in fact filed their appeal and they are also seeking a stay of that decision up in the 7th Circuit. So the state's primary argument is that Judge McGlynn misapplied Bruin and the 7th Circuit's decision in Beavis, and because of that, the decision should be stayed. They go on also to argue to the 7th Circuit that the court should stay the injunction pending appeal. Defendants are likely to succeed on the merits because the district court's opinion fails to faithfully apply the court's opinion in Beavis and breaks with the unanimous view of the federal courts of appeals that similar regulations of assault weapons and LCMs are consistent with the Second Amendment. If it is allowed to take effect, moreover, the court's injunction will work serious and lasting damage to public safety within Illinois. Now, one of the interesting things with this appeal and the request for the stay that Illinois is making is that the state is maintaining the hardline approach that these rifles and magazines are not arms at all covered by the text of the Second Amendment, even though they are owned and used by millions of people within the United States. The state here of Illinois is arguing that they are not protected arms at all. Now, in response to the request for a stay, the plaintiffs here have filed a reply arguing, of course, that the stay should be denied by the Seventh Circuit. In the brief, they point out that from the very start, the state of Illinois made a procedural error. The plaintiffs here point out that under the federal rules, the state of Illinois, like everyone else, is first required to ask the district court for a stay before they jump the line and then go to the Seventh Circuit. The only time they could bypass the request to Judge McGlynn would be if they argued that it would not be practical, it would be impractical, that for some reason going to Judge McGlynn would be futile, so that's why they would need to go to the Seventh Circuit immediately. However, the state did not go to Judge McGlynn for a stay, and they do not allege in their stay request to the Seventh Circuit that such a request would not be practical to go to Judge McGlynn. And based on the procedural blunder alone, the plaintiffs here are arguing that the stay request should be denied. The plaintiffs state in their brief that the state has not even tried to show that seeking that relief from the district court first would be impractical, nor could it. The 30 days the district court gave the state provided ample time to seek a stay pending appeal. In any event, it has forfeited any chance to do so now. The plaintiffs also point out that the state failed to provide proper notice of the stay request to all of the parties, and again, that's required under the federal rules, so the state of Illinois was pretty anxious, I guess, to get this in the hands of the Seventh Circuit immediately. They've had favor in the Seventh Circuit. The left-leaning Seventh Circuit has ruled in their favor on this issue before, so I guess they got anxious and wanted to get this in the hands of the Seventh Circuit immediately, but in doing so, they broke a bunch of rules. And because of that, the plaintiffs are now arguing that the stay request should just be outright denied because the federal rules were not followed. However, I also want to point out that the Seventh Circuit recently asked for the parties in this case to file additional briefs on whether or not the Seventh Circuit should remand this case back down to Judge McGlynn right now for a limited time period to revise his judgment. I anticipate that the Seventh Circuit will in fact remand this case for a limited time period for that very purpose. If that happens, well then Illinois will have the opportunity to fix their errors and then seek a stay from Judge McGlynn, which will probably be denied, and then they would just go back to the Seventh Circuit for a new stay. Now, the general issue with the Judge McGlynn judgment, according to the Seventh Circuit, is the Seventh Circuit believes it does not expressly state what relief is being given to the plaintiffs and what conduct the defendants are going to be barred from engaging in. The Seventh Circuit stated that the separate judgments entered in these cases failed to provide any relief and merely state that the judgment is entered in favor of each of the plaintiffs against each and certain defendants. So the Seventh Circuit wants to send this back down to Judge McGlynn for more express orders. They want the relief to be more outlined about what the plaintiffs are winning and then also what the defendants are barred from doing. So if you were to ask me what's going to happen, I think this case is going to get kicked back down temporarily for a revised judgment. Then Illinois will take that opportunity to fix all of their stay request errors, to go to Judge McGlynn, to seek the stay, get it denied, and then go to the Seventh Circuit properly. So the state of Illinois might get off on a technicality, but regardless, we know that the Seventh Circuit is probably going to show them favor. They're probably going to issue an opinion on the merits of this in favor of the state of Illinois. And this is one of those cases that's going to need to make its way up to a higher court like the en banc panel and probably eventually to the Supreme Court. So this is a very interesting battle that's going on right now in regards to the stay request and then also the judgment and potential errors that Judge McGlynn is claimed to have made by the Seventh Circuit, and the Seventh Circuit wanting to maybe stall this case a little bit longer and send this back down to Judge McGlynn for a revised judgment. So as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.